Good day, everyone. I'm going to present to you the case of ALDABA versus COMELEC with GR number 188078, March 15, 2010. For the facts of this case, this resolves the motion for reconsideration of Respondent COMELEC of the decision dated January 2010. The COMELEC grounds its motion on the singular reason already considered and rejected in the decision that Congress' reliance on the certification of Alberto and Miranda, Region 3 Director, NSO, projecting Malolo City's population in 2010 and other sources population indicators as of 2007, the PMS-3, and as of 2008, the certification of the City of Malolos Water District and the certification of Liga ng Barangay, which Congress allegedly used in enacting RA number 9591 as non-justiciable. So basically, Miranda issued a certification using the established population growth rate of 3.78% between 1995 and 2000. Its population in 2010 will be 254,030. Congress enacted RA 9591 to amend the Charter of City of Malolos, making the city a separate district from the existing 1st Legislative District of Bulacan. This brought petitioner Aldaba to assail the constitutionality of RA 9591 for being violative of the requirements of Article 6, Section 5, Subparagraph 3 of the 1987 Constitution. So the issues of this case are the following. Number one, whether or not the COMELEC's motion that the Congress reliance on the certification of Miranda on Malolo City's population in 2010, the PMS3 report, the certification of the City of Malolos Water District, and the Liga ng Barangay in enacting RA 9591 is non-justiciable. Second, whether or not RA 9591 is unconstitutional for being violative of Section 5, Subparagraph 3, Article 6 of the 1987 Constitution. So for the rulings of this court, anent the first issue, the court ruled that no, the COMELEC's motion was not granted. It is well settled that the passage of apportionment acts is not so exclusively within the political power of the legislature as to preclude a court from inquiring into their constitutionality when the question is properly brought before it. It may be added in this connection that the mere impact of the suit upon the political situation does not render it political instead of judicial. To deny the court the exercise of its judicial review power over RA 9591 is to contend that this court has no power to determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government, a duty mandated under Section 1, Article 8 of the Constitution. More so, the Miranda certification, the progress enumeration report, the certification of the City of Malolos Water District, and the Liga ng Barangay are unreliable because none of them qualifies as authoritative population indicator under Executive Order 135 to elevate the water district's so-called population census to the level of credibility NSO certifications enjoy is to render useless the existence of NSO. They are not authorized to conduct population census, much less during off-census years. This is especially applicable to the Liga ng Barangay. The COMELEC unwittingly highlighted the danger of relying on non-NSO authorized certifications. Anent the second issue, the court ruled that yes, RA 9591 is unconstitutional for being violative of Section 5, Subparagraph 3, Article 6 of the 1987 Constitution. The certification of R.D. Miranda, which is based on demographic projections, is without legal effect because R.D. Miranda has no basis to issue the certification. The certification is also void on its face because based on its own growth rate assumption, the population of Malolos will be less than 250,000 in the year 2010. As such, it failed to comply with Section 5, Subparagraph 3, Article 6 of the Constitution on the population requirement. More so, the creation by RA 9591 of a legislative district of Malolo City, carving the city from the former legislative district, leaves the town of Bulacan isolated from the rest of the geographic mass of that district. This contravenes the requirement of Section 5, Subparagraph 3, Article 6, that each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory. It is no argument to say, as the OSG does, that it was impracticable for Congress to create a district with contiguous, compact, and adjacent territory because Malolo City lies at the center of the first legislative district.